Okay, thank you very much, Elliot and Julia, and all of the members of the policy committee, all of your respective organizations, and all of your members for the great work that you're doing, and for the opportunity to join you today and speak to you about this important and very complicated, complex topic. As I think Elliot mentioned, the procedures can be daunting and confusing, and the overlay of the Highlands Act processes only compounds that in a lot of ways. So I'm going to give a presentation that talks about the municipal land use law, its connections to the Highlands Act land use procedures, and how that sort of all fits together, and what the opportunities are to get involved as a member of the public, and how the land use board's decisions are circumscribed by these laws. So again, thanks. I'm really honored to be with you all today and to talk about this. I learned a lot in preparing for this presentation. Some of this may be, you may be familiar with a lot of these concepts. It may be review for you, but I think it helps sort of frame the overall topic. So with that, I'm going to share my screen. So this is going to be a discussion of the municipal land use law in the New Jersey Highlands, and it's really intended as an overview of the various processes. There's a lot of information. It's kind of dense, but I think it covers the landscape. So as Elliot mentioned, home rule really is the backdrop for this entire conversation. We have 565 municipalities in the state, 88 of which are in the Highlands. And the concept of home rule is really that it's based on the idea that local governments are in a good position to understand the needs of their community and should have the authority to protect the health, safety, and welfare of the community. But that is not unlimited. That authority that the state has given to municipalities is not unlimited. It has to be consistent with state law as well as federal law. The New Jersey Constitution gives municipalities a lot of authority and deference in enacting those laws. And in Article 4, Section 7, Paragraph 11, you can see that where the Constitution says that laws concerning municipal corporations shall be liberally construed in their favor, and that municipal power shall include not only those granted in express terms, but also those of necessary or fair implication. That's sort of intended to create some gaps that municipalities can fill in as public health, safety, and welfare needs arise. Again, you see this limitation on municipal authority in this provision of the Constitution, which says that those municipal regulations cannot be inconsistent with or prohibited by the New Jersey Constitution or statutes. Even before that provision of the Constitution, in 1917, you had the legislature granting broad municipal authority to regulate issues of public health, safety, and welfare, and that's in the Home Rule Act, which contains similar language. It gives municipalities the authority to make, amend, and repeal ordinances that are not contrary to laws of the state. Again, you see that limitation, that are necessary and proper for preservation of public health, safety, and welfare of the community. So this language is broad. It's intended to give municipalities leeway in regulating what they perceive to be the public health, safety, and welfare issues in their community. And again, as Elliot mentioned, the zoning power is part of the police power. The police power is the power of government, generally the power of government to regulate public health, safety, and welfare. It's sort of the essential function of government. And the police power really derives from the English crown. Before there was the United States, that essential function of government was transferred from the British crown to the American colonies. Prior to the United States, New Jersey included, and that police power was delegated, at least insofar as it pertains to municipal land use, through the Municipal Land Use Law, which was adopted, I believe, in 1975. Prior to that statute, there were predecessor statutes. There was the 1926 Zoning Act. So the Municipal Land Use Law wasn't the first statute, but it's the most recent comprehensive state statute regulating municipal land use. Elliot covered that provision of the Constitution, which expressly authorizes the legislature to adopt laws delegating the zoning power to municipalities. And it's important to note that what the legislature giveth, the legislature may taketh away. And that concept is reflected in that constitutional provision. Municipalities do not have an inherent authority to zone. It's subject to what the legislature delegates to them by way of statute. And the Highlands Water Protection and Planning Act was one such statute. And it's really predicated on the recognition by the legislature of the value on a state level of the Highlands natural resources, drinking water supplies, and a recognition that those resources would be threatened if they were left at the mercy of uncoordinated municipal land use decisions. If you had 88 municipalities granting variances for projects in a piecemeal way, this is an issue that the legislature recognized needed to be coordinated. And obviously that was a dramatic legislative act that sort of ran against what some of the prevailing notions of home rule, in that, and I think it was perceived to be a loss of municipal authority, and not surprisingly, there were challenges to the constitutionality of the Highlands Act. Of course, it was upheld. There were takings claims brought, and the courts have rejected those claims, and in recognition of the hardship waiver procedures under the Highlands Act. So the Highlands Act, creates this coordinated system of regulation between the Highlands Council, the New Jersey Department of Environmental Protection, and municipalities. And the Highlands Act authorized DEP to adopt environmental regulations for the preservation area. Those include a prohibition on development within 300 feet of Highlands open water, measures to ensure existing water quality is maintained, restored, or enhanced, regulations of water diversions of more than 50,000 gallons a day, septic system density standards to prevent degradation of water quality, a zero net fill requirement for flood hazard areas, anti-degradation provisions for surface water quality and stormwater regulations, a prohibition on more than 3% impervious surface for an existing lot, and a prohibition on development that would disturb upland forested areas in order to protect forest resources, water quality, and critical habitat. DEP is also involved in the review of major Highlands development. DEP approves those by way of the Highlands Preservation Area approval, and that's required for major Highlands development in the preservation area, which is a defined term in the Act. It's also subject to 17 detailed exemptions for certain projects and activities. And depending on various factors, a determination of the exemption would either be made by the Highlands Council in the planning area, by DEP in the preservation area, and subject to council approval by municipalities. In certain cases, certain exemptions can be granted by municipalities. So the permitting process under DEP's under the Act with respect to DEP is first you have your Highlands applicability determination, which is really sort of the threshold determination. The DEP is deciding whether the project meets that definition of a major Highlands development or whether it qualifies for an exemption. The Highlands resource area determination is made to identify the location of Highlands resources. So in other words, it's sort of like a verification or a letter of interpretation process where you're identifying what the valuable Highlands resources are on the project that's proposed on the site that's proposed for development. And then DEP is then comparing that to its preservation area regulations as part of its review. Aside from the exemptions, there are also the 4 waivers that can be granted, and those are to protect public health and safety, which is made on a case-by-case basis, for certain redevelopment projects, where DEP determines that it's necessary to provide a waiver in order to avoid paying a private property owner for the effect of the regulations on the property, and also for 100% affordable housing projects. So, as I'm sure you all know, the Highlands Regional Master Plan is really the source of a lot of the regulatory authority for the municipalities, and really guides the land use decisions made in the Highlands region. The purpose is to protect and enhance the significant values of the entire region. And it includes the land use capability map and policies that are designed to guide planning and development based on the DEP environmental standards. Regional master plan also includes minimum standards for local master plans. So there you see the connections to DEP's environmental rules and also the local planning process. And the goals and objectives of the master plan, the regional master plan, are implemented through the conformance process, which is intended to incorporate the regional master plan into local planning. It's mandatory in the preservation area, voluntary in the planning area. And the conformance process includes revision of municipal master plans and land use regulations that are necessary to conform to the standards of the regional master plan. The conformance process requires municipalities to adopt land use regulations that are consistent with the Highlands Regional Master Plan. That includes a build-out analysis, the housing element and fair share plan, an environmental resource inventory, a municipal master plan element, and a land use ordinance and implementation schedule. And those are important because the master plan, the municipal master plan, is really the bedrock document in the municipality that really needs to be referred to and in the land use decision process. And generally, although there's exceptions, land use regulations need to be consistent with the master plan. So through conformance and requiring master plan conformance and municipal land use ordinance conformance, you're really implementing, or at least the intent was to implement the policies of the regional master plan into local land use administration. And of course, the Highlands Council has oversight over the conformance process. So I'll briefly touch on the municipal issued exemptions. 7 of the exemptions under the Highlands Act can be issued by municipalities that have gone through plan conformance process. That's pursuant to a memorandum of understanding between the Highlands Council and DEP. Those municipalities can issue those exemptions provided that the Highlands Council has approved the Highlands Exemption Ordinance of the municipality, and also that the municipal officers who will be implementing or administering those exemptions have completed appropriate training and certified to that effect. So the Highlands Land Use Ordinance really is an important part of this entire process, because there you are reaching down into the municipal land use administration process and with a regionally focused land use regulation. That the Highlands Land Use Ordinance is adopted and approved by municipalities as part of the Regional Master Plan conformance. It sets forth specific procedures for development review. The procedures are similar to the municipal land use law, and in some instances are the same, but there are exceptions, and I'll talk about those. In the preservation, any person who files an application for development has to comply with the Highlands Land Use Ordinance unless this proposed project qualifies for a Highlands exemption. So one of the differences between the municipal land use law and the Highlands Land Use Ordinance process is with respect to variances. Under the Highlands Model Land Use Ordinance, an applicant seeking variance relief for a prohibited use or from the mandatory residential cluster development requirement or from water availability requirements needs to go directly to the Highlands Council, whereas under the municipal land use law, ordinarily a developer seeking to build a prohibited use would have to go to the zoning board in the first instance for a D variance. There's also this process that's referred to as call-up, where the Highlands Council can review local land use approvals. Anybody who submits a development application in the preservation area has to provide notice to the Highlands Council. And the Highlands Council can review or call up the application in the preservation area within 15 days after the local municipal board makes its decision. So in any municipality where the council has approved the municipality's revised master plan or development regulations, call-up applies to applications that would disturb 2 or more acres or cumulatively increase impervious surface by 1 acre or more. And members of the public can request that the council initiate the call-up process. That's in the statute. After the council provides notice to the developer and a public hearing, the council will either approve or reject or approve with conditions within 60 days after the notice was given. And the council under the statute can only reject or conditionally approve the local land use decision if the development does not conform with the regional master plan, or if the council determines that the project would substantially impair Highlands resources. Ordinarily, under the municipal land use law, a member of the public who wants to challenge a local land use decision would take that challenge to the trial level of the Superior Court. That's not the case in with respect to a challenge of the Highlands Council's decision on call-up. Those challenges have to be brought directly in the appellate division of the Superior Court. And this sort of gets back to Elliot's opening remarks in the beginning of this presentation. The principle of deferring to municipalities and giving municipalities deference in their land use decisions. Under both the municipal land use law and the Highlands Act, when a municipality goes through the proper process of adopting its regulations, those regulations are given a strong presumption of validity if they're challenged in court. So that pertains to both the municipal master plan and development regulations, which have been approved by the Highland Council as being in conformance with the regional master plan, as well as your everyday municipal land use regulations that are adopted. And when you're in court challenging those regulations, it's not up to the municipality under the law to affirmatively defend its regulations. The challenger bears the proof of showing that the underlying decision was unreasonable. So, one of the themes of this presentation is the interlocking of the municipal land use law and the Highlands Act. And the purposes of the municipal land use law are consistent with the Highlands Act. And there are many statutory purposes of the municipal land use law. I've sort of highlighted here the ones which overlay with the Highlands Act purposes, and that is to encourage municipal action to promote public health, safety, and general welfare, to ensure that the development of individual municipalities does not conflict with the general welfare of neighboring municipalities or the state as a whole. So even there, you see a legislative intent to promote a comprehensive and coordinated process for administering land use. And also an environmental purpose to promote the conservation of open space, natural resources, and to prevent urban sprawl and degradation of the environment. And these purposes are important because, you know, if you find yourself challenging municipal regulation, courts generally like to look at what the purpose of the statute, the overarching statute is, because they sort of look at that as a touchstone in guiding their analysis of the dispute. And so it's important to recognize that the purpose of the municipal land use law is not just to promote development, it's also to protect natural resources and promote comprehensive planning. So municipal land use law is administered primarily through three municipal entities: the governing body, the planning board, and the zoning board. And they each have their statutory procedures and jurisdictions. The governing body prepares and adopts zoning ordinances, and also the ordinances governing the planning board's review of site plans and subdivisions. And I'll talk more about what those are in a bit. The governing body can also direct the planning board to re-examine the master plan. There's a statutory process which requires the planning board to re-examine the master plan every 10 years, but the governing body can direct the planning board to do a master plan re-examination in the interim. The planning board has the responsibility for preparing and adopting the master plan, which is, again, the guiding document for land use regulation in the municipality. Every land use regulation that's adopted by the governing body has to be referred to the planning board for a consistency determination before it's finally adopted. So the planning board will receive a proposed land use regulation from the governing body. They'll review it vis-a-vis the master plan, and then transmit a report back to the governing body as to whether the proposed zoning ordinance is substantially consistent with the master plan. And the planning board also has a review function in that it decides subdivision, site plan, and conditional use applications. The Zoning Board of Adjustment is a quasi-judicial body. It's really the entity in the municipality that's charged with hearing a case by a landowner as to why the landowner thinks that the zoning ordinance shouldn't apply to their particular project. There's specific procedures for that process, which I'll talk about. But those variations from the zoning ordinance are variances, and that's within the zoning board's purview. So starting with the governing body's zoning authority, it's not unlimited. The Supreme Court of New Jersey has, in a few cases, really sort of laid out what the contours of that power are. First, it has to advance, a zoning ordinance has to advance one of the purposes of the municipal land use law. There have been a few cases where the courts have struck down zoning for an improper purpose. So for example, in a case in Reddington, which you may be familiar with, which went up and down the court system in New Jersey, the court struck down an open space or struck down a condemnation ordinance because even though the ordinance said that it was intended to protect open space, the court really peeked behind the curtain, so to speak, and found an intent on the part of the local governing body to thwart an unpopular development project. So that was sort of an eyebrow-raising decision and really kind of cut against this concept that municipal regulations are presumed valid. And the court went beyond that presumption and really looked at what was going on in the community and sort of the political, the politics of the proposed development. The zoning ordinance also has to be substantially consistent with the master plan, as I mentioned, but it doesn't need to be if a majority of the full authorized membership of the governing body adopts a resolution stating why they're going to go ahead and adopt the ordinance anyway, and explains those reasons in a resolution and also in the minutes of the meeting. The zoning ordinance also has to comply with constitutional limits on the zoning power. For example, substantive due process. The ordinance has to be reasonable. And the zoning ordinance also has to comply with the procedural requirements. So for example, the municipal land use law prescribes specific notice and public hearing requirements, and those have to be followed in order for a zoning ordinance to be sustained. So just to sort of illustrate the limits on zoning power, oftentimes you see challenges to zoning ordinances being made by claiming that the zoning ordinance is illegal spot zoning. And that is zoning which is changed to benefit a particular private interest rather than the collective interests of the community. So that, going back to Elliot's opening remarks and the interest of people in the coalition and members of the public in sort of getting involved in this process and upholding the collective interests in preserving the Highlands, this sort of triggered spot zoning in my mind as something that could be considered in the context of those challenges. In the Raya Finnegan case, which the Supreme Court handed down in 2008, the court laid out the test for spot zoning, and that is whether the particular provision of the zoning ordinance is made with the purpose or effect of furthering a comprehensive zoning scheme, which is what it's supposed to do, or whether it's designed merely to relieve a lot from the burden of a general development regulation. And there again, notwithstanding the presumption of validity that is afforded to municipal land use regulations, the court was willing to go beyond that and to really look at the circumstances and what was going on sort of behind the scenes, so to speak. The court looked at a combination of factors. Was the rezoning request made by the property owner itself? Or was it made pursuant to a broader comprehensive planning process, which is really the way it should happen? For example, was the rezoning made pursuant to a master plan amendment or re-examination? Or was it just a property owner with a development idea, didn't want to go through the zoning board process and called up a buddy on the governing body to lobby for a zoning change? The court will look at those types of circumstances. The court also said that it would look at whether the governing body heard from experts in support of the rezoning. So again, if the rezoning seems to be inconsistent with sound planning, the court may consider whether the governing body heard from a professional planner and whether that planner supported the rezoning. So getting into the process for the zoning ordinance adoption or amendment, and this is where the public has an opportunity to get involved. There will be two public meetings that have to be open public meetings, at least two public meetings. You'll have your first where the ordinance will just be read by the title. You won't necessarily get into all the provisions of the ordinance. There may be an opportunity for public comment, but it won't be as broad as the public hearing process. If the ordinance is adopted on first reading, that's really a decision by the governing body to go on at a subsequent meeting and consider the merits of the ordinance. But before it does that, it refers, at this first meeting, it will refer the zoning ordinance to the planning board for the master plan consistency determination. And if the planning board doesn't get back to the governing body in 35 days, it's presumed to be consistent with the master plan. Now there's notice and public hearing requirements. The ordinance has to be published in a newspaper at least 7 days before the public hearing. There's enhanced notice requirements if the zoning ordinance is really like a dramatic change, if it's going to change what the permitted uses are in the zone district, or if it's going to change the boundaries, then the municipality has to go through what can really be a pretty time and resource consuming exercise of providing personal notice to everybody within 200 feet of the proposed change of the boundary, or everybody in the zone if you're changing the uses. And then after the first public meeting, you'll have another public meeting at which a public hearing will be held on the proposed ordinance. And there, the public has the right to come up before the members of the governing body at a public meeting, and the public has a right to make relevant comments and ask questions about the zoning ordinance, ask questions from their elected representatives. And those meetings can really be conducted in the discretion or in the manner dictated by the governing body. The governing body can ask their planner to come up to the microphone and address questions. They may not, but certainly the public has the right to ask questions, make comments about the proposed ordinance, and that will become part of the record of the governing body's decision. And then at the close of the public hearing, if the ordinance is adopted by the governing body, it has to be published. That decision has to be published in the official newspaper of the municipality. So that's the governing body. The governing body creates the land use laws. The planning board is one of the two boards that's responsible for implementing them. And they do that through subdivision control and site plan review, through conditional use review and approval, and through a certain variance called a bulk variance. That's only, the planning board can only get involved in a C variance or a bulk variance if it's incidental to the planning board's run-of-the-mill functions in reviewing site plans and subdivisions. And again, the planning board also is involved in adopting and preparing the master plan. So the master plan contains several elements. It's similar in format, or at least in concept, to the regional master plan. You have various elements, which you'll have color pictures in there. You probably have all seen a master plan. It's a graphic document that includes an analysis of the existing uses in the town, what's proposed, what would be appropriate given the natural conditions in the town. It'll include a housing element, including a discussion of affordable housing. The municipal master plan has to include a land use element, and it has to include sort of a discussion of the objectives. It may include several other elements, including traffic circulation, utility service, community facilities, and several others. So the planning board goes through this master plan process after providing notice and a public hearing. And then it has to re-examine the master plan and the zoning ordinance every 10 years and make recommendations to the governing body. And this is important, again, in terms of sort of piercing the armor of the presumption of validity that municipal regulations are vested with. Anybody who's interested in challenging a zoning ordinance should figure out whether the planning board has done its statutorily required master plan reexamination. Because if it hasn't, the municipality's development regulations lose their presumption of validity. And that shifts the burden onto the municipality to affirmatively defend its zoning ordinances and development regulations. So I've mentioned a couple times, the planning board is responsible for reviewing and approving subdivisions and site plans. What exactly are those? The municipal land use law defines those terms. A minor site plan or a minor subdivision are really left to local ordinances to decide what the scope of those developments can be. So, that'll either be in terms of the size of or the number of lots for a subdivision, or the number of units with respect to a site plan. But the statute does say that minor site plan approval and minor subdivision approval cannot be granted for planned development, which is sort of a larger, comprehensive development of usually several lots, or any development that is going to require a new street or street extension or substantial off-track improvements. And if it's not a minor subdivision or a minor site plan, then it is considered a major site plan or subdivision. Okay. So subdivision and site plan review under the municipal land use law is sort of a two-step process. You have your preliminary review and your final review and potentially final approval. At the preliminary stage, the board deals with public health and safety issues attendant with the project. So for example, making sure that there is water supply, adequate sewage disposal, and appropriate traffic circulation for the project. So water supply and sewerage not only have to be sufficient from an engineering standpoint, but at the preliminary stage, the applicant may have to demonstrate that they've got contracted capacity with the water utility or the sewerage authority to connect their proposed development. And oftentimes you'll see preliminary subdivision and site plan review being conditioned on other approval by other government agencies. For example, if it's a waterfront development, it'll be conditioned on DEP issuing a waterfront development permit, or you'll see them be conditioned on Board of Health approval for on-site septic systems. Your preliminary approval vests for 3 years. Once the planning board has issued preliminary approval, the terms of that approval can't be changed, and the development regulations applicable to that approval can't be changed for 3 years, unless there's sort of minor changes that are necessary for public health, safety, and welfare. The next step in the process is the final subdivision and site plan review. A developer who's gotten preliminary approval has to submit their application for final subdivision or site plan review within 3 years of preliminary approval, and has to demonstrate that the conditions of preliminary approval have been satisfied. If the developer can't do that and can't get final approval, the developer can't get a building permit for the project, can't start construction. There are limits, of course, to the planning board's site plan and subdivision review, and generally that process is a very constrained process. The New Jersey Supreme Court has said, and this is really important in terms of the expectations of members of the public when they come out to voice their opinions or possibly object to a project that's subject to site plan or subdivision review. The New Jersey Supreme Court has said that planning boards do not have the authority to deny those approvals based on considerations of the general welfare, the purposes of the MLUL, and sound planning. The board can only reject a subdivision or site plan application if that application does not meet the specific requirements which are in the municipality's adopted subdivision or site plan or zoning ordinances. The planning board can attach conditions to site plan or subdivision approval. And again, those are limited to on-site access improvements. So, the driveways in and out of the property. They can require the developer to contribute to their fair share of making off-site infrastructure improvements, like road improvements that are necessitated by the development. So, I just mentioned that the planning board's review of site plans is constrained and limited to what's in the ordinance. And I just wanted to give you a sense of what, in substance, those specific requirements are, what they deal with. And you can see here, I've got like a list of what is authorized by the municipal land use law to be included in a site plan ordinance. And they really deal with sort of site-specific issues, public health and safety issues. So the layout of the site, street width, whether there's adequate shade trees, drainage, sewerage, reservation of open space. This is sort of a nuanced requirement. Planning board cannot necessarily require a developer to give open space in connection with the development. This is referring to the planning board's authority to require the developer to set aside open space which will later be purchased by the municipality, and a host of other specific requirements which you can see here. Based on my experience, you see oftentimes traffic being an issue and members of the public being concerned about traffic. And again, it should be understood that increased traffic cannot be the basis for a planning board's denial of a permitted use. Traffic can come into play in a variance decision, but with respect to site plan and subdivision review, the board can't deny those applications based on concerns about increased traffic. And I think that's something that there may be a commonly misunderstood. And this brings us to the third and final board that implements land use, and that's the zoning board. The zoning board really has 4 areas of jurisdiction. It can hear appeals from a local administrative officer. So for example, where a property owner, where someone buys property that has a pre-existing non-conforming use on it. So that is, there's a structure or an operation on a site, and then the zoning is subsequently changed. The property owner may be able to continue that use notwithstanding the subsequent change in zoning. And oftentimes the property owner will want to get a zoning certificate from the zoning officer to kind of make it official. Like, hey, municipality, you recognize that this is a pre-existing non-conforming use, and I want my piece of paper that says that. If the zoning officer denies that, then the property owner can appeal that to the zoning board. The zoning board also has the authority to hear direct applications that call for a specific interpretation of the zoning ordinance. So, for example, if the planning board is considering an application for development and an issue comes up during the process about whether what the applicant is proposing really qualifies under a specific meaning or term in the zoning ordinance, or it's not really, they really want the zoning board's input on whether that term applies, they can request the zoning board issue an interpretation of a specific term in the zoning ordinance. Not decide the application, but sort of get involved in a consultative role as to what the zoning ordinance means. The zoning board has, and this is probably the most important aspect of their jurisdiction, the authority to grant or deny bulk variances, which are referred to as C variances, and D variance applications. And that's really where developer is trying to get away from the requirements of the zoning ordinance. The zoning board also has the authority to issue site plan approval or subdivision approval if it's incidental to a D variance. So for example, if somebody wants to build a prohibited use and applies for a D variance to do so, the property owner can also submit a site plan application to the zoning board. And that's really done just, I think from the developer's perspective, in the interest of efficiency and going before one board versus two separate boards, two separate processes. So again, boards can impose conditions. They can, if the board's gonna issue a variance, it can impose conditions to mitigate the negative effects of the variance. And that's important because variances are disfavored. We have a comprehensive process envisioned by the municipal land use law and by the Highlands Act and those procedures, which really are intended to promote sound planning and not piecemeal development approval. And that's really what a variance is. It's sort of a decision to relieve a property owner, or actually a specific piece of property, from the regulations of the zoning ordinance. This is an instance where the property owner really bears the burden of demonstrating that the variance should be granted. Variances run with the land. So if a property owner is granted a variance, it subsequently builds their project, operates their project, and sells the property, that variance, the subsequent purchaser will have the benefit of the variance, unless they seek to expand or change that existing use. So oftentimes in the context of variances, you'll hear the phrase positive and negative criteria. A property owner has to demonstrate both the positive and negative criteria for any variance, for a C variance, for a D variance. They have to demonstrate both. And what are those? The C variance, for a C variance, the positive criteria include undue hardship. So the property owner has to show that there's an undue hardship caused by really the conditions of this, the physical conditions of the site itself. It's exceptionally narrow, it's got a weird shape, it's unusual topographical conditions, or physical features that uniquely affect the specific site. The applicant also has to demonstrate the negative criteria. And this is where, you know, sort of general considerations about the project come into play. The applicant has to prove that the granting of variance would not result in substantial detriment to the public good or substantially impair the intent and purpose of the zoning plan or the zoning ordinance. So examples of a C1 variance are reduced setback requirements for a building on an oddly shaped lot. So, you know, your setback requirements require minimum distance between the edge of the lot and the structure. If the lot's got a weird shape and it may be difficult for the property owner to comply, the board may grant a variance. Another example is a relaxed height limit for a building on a slope. Oftentimes the zoning ordinance will prescribe formulas for calculating height. And that, if a building's on a slope, that may in effect give a building on a slope a lower height than would otherwise be permitted. And so a C1 variance could be granted in that instance. You also have a C2 variance, which is a little more nebulous than the C1 variance. And you know, when you look at the C2 variance, it sort of raises the question of how it relates to a D variance. And I'll get into that, but a D variance allows you to do a use that is not permitted. It's really a drastic relief. It's not permitted under the zoning ordinance. And it should be noted that a C2 variance cannot be used to grant relief that's what a D variance is for. So for example, you can't apply for a use variance by way of a C2 variance. A C2 variance is different in that the applicant doesn't have to show undue hardship, but the applicant still has to meet the positive and negative criteria. So an applicant can do that by proving that the variance would carry out a statutory purpose of zoning under the municipal land use law, and that the benefits of the variance would outweigh the detriment. And again, the negative criteria apply as well. So the variance cannot or would not result in a substantial detriment to the public good, and it would not substantially impair the intent and purpose of the zone plan or the zoning ordinance. So in the real world, what is a C2 variance used for? An example would be relaxing the front yard requirements in order to protect a stream crossing in the rear yard. So, you know, DEP regulations require buffers between development and streams, and there may be a countervailing pressure on the development by way of the front yard requirements. So if you have to have a large front yard, but you also can't develop too close to a stream in the backyard, the zoning board may grant a variance from the front yard requirements, not the stream buffer requirements. But in that case, the applicant would have to demonstrate that doing so carries out a purpose of the municipal land use law, which I mentioned before includes conserving natural resources. D variances are really the controversial variances because that's where you get into projects that are prohibited under the zoning ordinances but may approved. So there's 6 different types of D variances. There's the use variance, which I've mentioned. There's the D2 variance, which allows an expansion of a pre-existing non-conforming use. So again, that's a project that was built before a change in the zoning ordinance. It's allowed to continue because the zoning ordinance came later, but then maybe a subsequent owner of the site wants to expand it or make it ramp up production if it's a commercial site. The property owner would have to go in for a D2 variance. A conditional use variance. So I haven't talked much about a conditional use, but a conditional use is essentially a permitted use. It's something that's allowed, provided that the applicant meets certain enumerated conditions in the zoning ordinance. So if a property owner can't meet one of those specific conditions, it would have to go in for a D3 variance to the zoning board. A D variance is also required to increase the permitted square footage or floor area ratio of a structure. D5 variance is required for an increase in density of the project, and a D6 variance is required where a proposed structure would exceed the maximum permitted height by 10 feet or by 10%. So a project that would exceed the permitted height by less than that would probably go in for a C2 variance instead. As I mentioned before, the variances should be granted only in exceptional cases. And that's important to remember as a member of the public when you're going into these public meetings, which can be daunting and keeping in mind that there's a presumption of validity with municipal action. Really in the variance process, that changes because the board's ultimate decision is accorded some deference, but the burden in the process really falls on the developer to prove that his or her case isn't an exceptional case. And again, the applicant has to satisfy both the positive criteria and the negative criteria. And for a D variance, the positive criteria is referred to as special reasons. Now, you may have heard of inherently beneficial uses. These are uses which are presumptively determined to meet the positive criteria. So some of them are set forth in the statute. Others have been created by the courts through litigation. Affordable housing is an inherently beneficial use, but not just any project that includes some level of affordable housing. 20% has historically been the benchmark for inclusionary development, but that is not enough to presumptively satisfy the positive criteria. Wind and solar power structures are an inherently beneficial use. And again, these are uses which have been deemed by the legislature or the courts to be, good for society and good for the community. And the idea is that the applicant would bear less of a burden in demonstrating why the variance should be granted for these kinds of uses. Hospitals, schools, renewable energy facilities. A couple that are sort of controversial and were not in the municipal land use law but have been addressed by the courts are cell towers. Cell towers are not automatically treated as a inherently beneficial use. Cell towers that have an FCC license, there have been cases which have found that those can be treated as an inherently beneficial use. Same with the house of worship, churches, mosques, synagogues. But again, those are unsurprisingly controversial. And really, those two particular types of projects, cell towers and houses of worship, get into federal licensing regulations and First Amendment rights with respect to houses of worship, which really open up a can of worms that kind of get beyond the scope of this particular discussion. So how does a developer demonstrate the positive criteria? They have to show undue hardship. And how do they do that? One way would be to show that they can't get an economic benefit from the project. The developer doesn't have a right to the most profitable use. Sometimes developers don't recognize that, and you may hear them claiming that a municipal regulation should be set aside, or that they shouldn't have to comply with it because they have a project that's, that it prohibits a project that would give them more of a financial benefit, but that doesn't entitle them to a variance. Total economic inutility may be considered, but that doesn't necessarily entitle the property owner to a variance. If there's outdated structures on the site, that may be something considered by the board. So for example, if there was old zoning on Main Street, which only allowed retail on the ground floor, but in the ensuing decades, shopping malls were developed. This is probably less relevant in the era of Amazon, but if shopping malls are pulling away businesses, and it really doesn't make sense anymore to limit ground floor uses on Main Street to commercial, then perhaps that's something the board could consider. Another example of something to be shown for undue hardship would be split lot zoning. So that's where you have a zoning boundary running through a single lot. So you have two uses permitted on a single lot, one on one area of it, one on another. So for example, if you have a portion of a lot that fronts a street, which is zoned for commercial, but the rear portion of the lot can only be used for residential, that may make complying with all of the development standards for residential difficult, and that might be something that you would see a developer pointing to support a D variance application. And then boards have the ability to consider other sort of fairness considerations, and those really come up on a case-by-case basis depending on the particular circumstances. Another way that a D variance applicant can demonstrate the positive criteria is by showing that the proposed use would promote one of the municipal land use laws specific zoning purposes. So what are some examples? Well, promoting safety in the free flow of traffic. But it's important to note there that just saying that your project as a developer, your project is going to create less traffic than permitted uses doesn't cut it. You would have to show that there's already a bad traffic situation in the area, that it's really causing a problem on the net. The project being proposed would alleviate that already bad situation. Another statutory zoning purpose which could be cited is the promotion of a desirable visual environment. An example there being an aesthetic improvement to a pre-existing non-conforming use. So generally you cannot expand a pre-existing non-conforming use, but a D variance would allow you to make an aesthetic improvement to that if you can show that it would just make this old structure look better, essentially. Another statutory purpose that could be that you may see come up is promoting appropriate population densities and senior citizen community residents. Real world example of that would be a variance to allow an accessory apartment on a lot, for the homeowner's parents or grandparents. The positive criteria can be demonstrated by projects that just generally promote welfare of the community, like public utility installations, seeing eye, dog facilities. But in any case, the developer has the burden of showing that this particular site is suitable for the variance. So not just in abstract terms. So the developer really needs to be pressed to answer, why is the location of this particular site within the region or the town particularly suited to the use, despite the zoning? I mean, the town knows what the conditions of this, is presumed to know what the conditions of the land in the municipality is, and decided to prohibit that use. But why do you see it differently? And what are the unique characteristics of the site itself that make it particularly appropriate for the proposed use? So an example of that would be a supermarket allowed in a developing residential area if there's no other supermarkets nearby, and if that supermarket would serve, other communities in the area. And again, negative criteria has to be demonstrated by the developer for all variances. They have to show that doing so will not harm the public or really substantially interfere with the zoning in the community. Time for board decision. This sort of gives you a sense of how long these processes can last. And overarching this topic is the concept of automatic approval, and I'll explain what that is after just sort of running through the general time periods. So for subdivisions, smaller subdivisions and smaller site plans, the time for the board decision is 45 days. For larger subdivisions and larger site plans, 95 days. Conditional uses are 95 days. Variances are 120 days. So that's the longest of the processes. And these time periods are measured not necessarily from when the applicant files their application, but from when the application is deemed complete. So it meets all the requirements on the checklist for what the application has to include. If a board doesn't adhere to these timeframes, the project is automatically approved. And I've seen it happen where, unpopular development is proposed and there's a lot of back and forth between the board and the applicant, a lot of community objections and advocacy against a project, and the board misses the deadline. All of a sudden that project is deemed approved. And that can happen if the board doesn't hold a public hearing by the deadline and doesn't make their decision by the deadline. The Supreme Court has said that there may be public health and safety exceptions to automatic approval, but hasn't created a bright line test. So that's sort of an open issue. We had a case where the Supreme Court decided not to get into whether a project that was in a federal flood zone after Hurricane Sandy should not be deemed automatically approved on the basis of public health and safety. Personally, I think that was a compelling case, but the Supreme Court decided not to touch that. So automatic approval is a third rail to avoid in the local land use process. So a little more about what that process is like. The planning board and the zoning board must give notice and hold public hearings on applications for development, except for conventional site plan, minor subdivision, and final approval. So these are, generally smaller projects or projects that have already received preliminary approval and are now just going in to show that those conditions have been satisfied and that the project hasn't changed materially since preliminary approval was issued. Public notice has to be given at least 10 days before the public hearing by publication in the newspaper, and it has to be given to property owners within 200 feet. If the municipality doesn't follow these processes, that can taint and derail the entire process. So that's something to look at in the context of a controversial development, whether the municipality has followed the procedures. Everybody can participate in the public hearing. The municipal land use law says that interested parties can participate. That's been interpreted to mean impacted property owners, whether they live in or outside the particular municipality, and whether they have a property right that is or may be affected. So that's a pretty liberal standard in terms of demonstrating that you have a right to be at the public hearing. You don't have to, you shouldn't have to make that case when you show up at a public hearing. You may see this come up in the context of a legal challenge if a developer is denied approval and wants to raise a stink about objections that were made at the public hearing and whether people had the right to be there. But also just citizens in general have the right to participate in the public hearing, either on the basis of being concerned about sound development and sound planning, or on the basis of being a taxpayer in the town. Now, how do you represent yourself at a public hearing or secure representation? Applicants will typically be represented by attorneys and a bevy of professionals. Interested parties, again, members of the public, can also be represented by attorneys at a board hearing. The applicant will introduce testimony under oath from qualified professional experts. So they'll come up to the microphone, typically in the public meeting room. They'll present their experts, go through their professional qualifications, and then the board will typically decide to accept the testimony of the professionals, or decide that they're qualified. These witnesses, the professional witnesses, are subject to questioning. They can be cross-examined by members of the public. All interested parties have a right to cross-examine witnesses at a public hearing. So what can you expect in terms of the sequence of a public hearing under the municipal land use law? This is sort of intended to demystify how this works in practice. So first, the applicant and his or her witnesses are sworn in by the presiding officer, which is typically the board chair or the board's attorney. The presiding officer can reasonably limit the time and the number of witnesses. So the presiding officer can try to limit irrelevant testimony, or for example, if a witness has been cross-examined on a particular topic several times, at some point the presiding officer has some discretion to limit duplicative testimony or questioning. The applicant then presents their case in support of the application. They'll explain the development. They'll have their witnesses come up and answer questions about, typically questions from the attorney about the technical nature of the project and how it complies with the zoning requirements. After which the board members and the board attorney will question the applicant and the applicant's witnesses. After the developer has presented her case, then interested parties will have an opportunity to get involved. An objector can appear individually. They can participate individually and ask questions or testify, or an objector can be retained by an attorney and testify by responding to an attorney's questions, which is really sort of like a courtroom format. And again, objectors can cross-examine the applicant itself if the developer itself is testifying, or the developer's engineers, professional planners who are testifying. Objectors also can present their own professionals. So if the project is controversial, an objector can come in with a professional planner, a professional engineer, and present objections and an opposing case to the proposed development in order to refute the applicant's testimony. The applicant bears the burden of proof at a public hearing of showing both the positive and negative criteria for the variance. One thing I wanted to point out, and this is something that seems to come up frequently, if there's a controversial project and a member of the public wants to demonstrate to the zoning board or the planning board that a project is unsustainable or really politically unpopular and circulates a letter to members of the community, that objection letter will not be part of the official record of the board's decision. This is really and that's because this is like a judicial proceeding. It's sort of like out of court testimony, but that letter will not become part of the evidence unless the people who have signed it or the person who is signing the letter testifies to the contents of the letter at the public hearing. At the conclusion of the hearing, the board will then vote either to deny or approve the application. The board then has 30 days to adopt a resolution, a written resolution memorializing their decision. That resolution will be adopted at a public meeting, but that's really, at that point, you're really beyond an opportunity for public hearing or public comment. Once that memorializing resolution has been adopted by the board, it has to be published. Notice of that decision has to be published in the official newspaper, and then that starts a 45-day clock that applies to potential legal challenges of the board's decision. So an objector, a member of the public, could file suit to challenge a zoning ordinance or a variance decision in the Superior Court, but that has to be filed within 45 days from the publication of the decision, not from the date of the meeting itself where the decision was made. So that's the end of the presentation. I realize I'm going to turn my screen sharing off so you can all see me again. I realize I covered a lot of material. It was intended to be sort of an overview of the process. I know it can be technical and there's a lot of detailed information there. But at this time, if anybody has any questions.
First question then came from Alex. Are conforming municipalities required to have an exemption ordinance in order to grant a variance?
Thanks, Alex. Yeah, I would have to look at that specifically. I think that a conforming municipality needs to have an approved exemption ordinance in order to grant an exemption. I can get back to you, Alex. If I can get your email, I can follow up with a specific answer to that.
Yeah, and so it's kind of a two-part question also, because my first question is, are conforming municipalities required to have an exemption ordinance at all?
The primary responsibility for issuing exemptions lies with the council and with DEP. There are limited instances where municipalities can grant some exemptions, but not all. In those instances, the municipality has to have an approved exemption ordinance.
It's purely at the discretion of the municipality, purely voluntary. If they want to have an exemption ordinance, they can adopt one, but it's not mandatory.
Do we have a sense of how many municipalities have one right now?
I don't have a sense of that. I don't know.
It's far from a majority.
Okay, that's what I figured. Okay, thank you.
Thank you.
And you can find that out on the Highlands Council's website if you want to know about a specific community.
Chris, I think subsequent to this question being asked, you covered it in some detail, but could you explain in a little more detail what a bulk variance kind of alludes to? Where does the term bulk come from?
Yeah, bulk variance really deals with like the size or the bulk of the structure, really, in relation to the physical conditions of the land itself that is being proposed for a variance. So again, this would be, you see bulk variances or C variances, and the C is just the section of the statute, come up where the development standards, so like the real technical standards applicable to the development, like a setback, where the physical conditions of the property make it difficult to comply with setback requirements or things like that. But again, it really, as distinguished from a D variance, which gets into sort of the bigger, issues of hardship and showing, getting a prohibited use allowed. This is really more designed to deal with, technical, waivers from the technical requirements applicable to development.
Excellent, thank you. This is another question. It's a bit more specific. Someone asked, what percentage of affordable housing would be sufficient to constitute presumptive satisfaction of the D variance positive criteria? Shall I repeat that? Did you get it?
Yeah, I did. I really appreciate that's a great question. There was a case about 10 years ago, which determined that that 20% affordable housing was not sufficient to constitute the positive criteria. And the courts, to my knowledge, have not yet waded out into the waters of how much what level of affordable housing should be sufficient. 100% affordable housing can get, in some cases can get you a waiver under the preservation area rules. That's separate from the variance question. So the short answer is it hasn't been addressed by the courts yet. But I mean, from a policy perspective, I mean, my personal view is it should be substantial, way more than 20%, maybe 80%, 100%, given the need for affordable housing. And if you're going to, give a developer relief from the zoning ordinance, then there should be, it should be predominantly affordable housing, not market rate units.
Yeah, very good. Another question asked, what does best and highest use mean in the legal sense?
Highest and best use, in my experience, I mean, that really comes up in terms of valuation in the context of condemnation proceedings. So, that'll be where a municipality wants to take property by eminent domain, or where a developer or property owner is claiming that a regulation has deprived them of their property rights. You'll hear this phrase come up, and typically what it means is the highest and best use. I think that the developer would argue, what is allowed under the zoning and what's appropriate for the site, and really more of what's appropriate for the site. And their motivation there is profit, essentially, and trying to argue that they're entitled to more compensation from the municipality. So I don't think, I'd have to check on this, I don't think that is a term that specifically comes from the municipal land use law. I think that is sort of in practice something that comes up in the context of valuation and condemnation, and you'll typically have experts on behalf of the municipality and of the property owner, doing an analysis and submitting reports in a condemnation context about, what the highest and best use is.
Sure, open to interpretation a bit. The next question is the 120-day limit only applicable to D variances or all variances?
I believe it's for all variances, both C and D.
Okay. That was an easy one. And then what about development applications that cut across more than one municipality? For example, utility line development. In that case, there is no local public hearing. What rights do the public have to be heard in that circumstance?
That is a very specific circumstance. I can look into that and follow up with you, Mark. It sounds like maybe you have a specific project, or there was a specific case in mind, so we could talk about that.
Excellent. So one final question from the chat feature. You can probably all see it, but I'll read it out. Please explain objector's right to appear individually or not if he/she is a member of a group that has already retained an attorney.
So anybody has a right to appear in a public hearing under the municipal land use law. A member of the public can be retained by an attorney. I believe a member of the public can be part of a organization. I mean, and also appear in their individual capacity. I believe an attorney can come and you can come and make comments on behalf of an organization, but again, you're going to be subject to cross-examination, and that gets a little tricky in terms of representing the group itself. I'm not aware of any specific limitation in terms of on your right to participate by virtue of being a member of a group, but again, maybe there's some specific facts, George, that you could let me know offline, and we could have more of a discussion about that or follow up via email.
I have seen at planning board meetings, people, if they say they're part of a group and the group is represented by an attorney, that we've seen planning board attorneys prevent people who say they be part of that group of standing up on their own.
Okay, so thank you. That's helpful in terms of the context. I think what may have happened there is the planning board attorney trying to limit, they're probably taking the position that they're limiting duplicative, I mean, not to say that this is the correct approach, but probably taking the position that they're limiting duplicative testimony. I mean, I'm speculating as what the approach, the mindset may have been, but generally, the presiding officer at these meetings can limit duplicative testimony, and perhaps this attorney was thinking, well, your views have already been represented by virtue of your group, and so I'm limiting duplicative testimony.
And Chris, that happened to us at Billy's Court when EELC was representing us. But,
really? Okay.
Yeah. But we could easily be here all morning and afternoon asking you questions, and I think we're going to have to invite you back to do that, because we all have questions about this. This was a very thorough, very interesting presentation. I'm really thrilled that you participated in this for us, and I think everybody here appreciated it. This is a good way to get to know you, the new executive director of EELC. We wish you the best.